My name is Amy Habe. I am the compliance officer with the board, and I will be doing the presentation today. John Wilbeck, executive director, is here with me, as well as Allison Berglund, who is our public information officer. The chat box is open. You can use that to ask questions. John will be monitoring that, kind of typing as we go. And then we will also stop and have time for other questions along the way. So just some housekeeping things here before we get started. Again, the webinar starts around 12. All participants are muted. You should be able to hear me, and John or Allison, but everybody else is muted. Again, use the chat box to ask questions. We do anticipate that the board will give continuing education credit for the webinar, but as a reminder, the board does not pre-approve CE offerings. So if you plan to use this for continuing education, please know that certificates will not be issued as attendance verifications. If you stay for the entire presentation, you will receive an email from Allison within a week confirming your attendance. So you might need to check your email's junk folder or any other folders that it might go into. But again, certificates will not be issued, and an email will be sent as long as you stay for the whole presentation. So today we're going to be talking about professional practice and ethics. The roadmap for the day, we're going to talk about enforcement, the complaint process and investigations, various case studies and sources, and then we will have a time, like I said, at the end for questions. So to start off, we are going to talk about enforcement. So the Nebraska Engineers and Architects Regulation Act handbook contains the statutes and rules for the Board of Engineers and Architects. So the first section lists the statutes that the board has authority to enforce, and then the second half is the rules of the handbook. The most recent changes were made May 6th of 2025, and so to the statutes. And the most recent revisions to the rules was November 25th, 2025. So the cover you see on the screen is our most up-to-date book. If you do not have the updated one, we'll talk about how you can request that from the board. But again, the act governs the practice of engineering in Nebraska in order to safeguard life, health, property, and promote that public welfare. You can also find a copy of the act on the board's website, which is ea.nebraska.gov. If you click on the enforcement tab there in red, and then the Nebraska Engineers and Architects Regulation Act, you will get the page that's back there that has the PDF link to the digital version of the handbook. All right, so to start off, we're going to talk about the statute that discusses the prohibited acts and penalties. So statute 813442 says it is unlawful to practice or offer to practice architecture or engineering without proper licensure. Knowingly employ or retain an unlicensed, non-exempt individual to practice. Using the title architect, engineer, or derivatives in a business name without authorization. Advertise in a way that implies licensure when not licensed. Use another person's license certificate or seal. Submit false or forged evidence to the board. Impersonate another licensee. Use expired, suspended, revoked, or non-existent license. Falsely claim licensure or otherwise violate the act, or violate the act. So the first offense is a class 1 misdemeanor. And then there's felony charges as well that can be brought. So we're going to talk a little bit about the complaint process and investigations. The board works with various state agencies as listed here on the screen. These are just some of the ones that we work pretty closely with. So we have the fire marshal, DHHS, NBEA, and other local building officials. And the goal there is just to protect the life, health, and property again and promote that public welfare. And we also work really closely with these entities to ensure that they're up to date with our information and any changes that the board has. This is not an exhaustive list by any means, but these are just some that we work closely with. So if someone were to want to file a complaint, anybody can do that with the board for any potential violation of the act or the board's rules. We get complaints in a variety of ways. Most come from other state agencies, members of the public, professionals in the building industry, professional societies, firms, etc. So it can be any alleged violation that you can file a complaint against, but anybody can file a complaint with the board if they feel there is an alleged violation of the act. More information on how to file a complaint can be found on our enforcement tab there under enforcement and complaints. And again, that page behind there has all of the information needed, all the documents and such, but we'll go into a little more detail on those documents, the complaint form, in a second. So here you see is a copy of our complaint form. The board asks that you complete the form as in much detail as possible. It gives the board a big overview of what the alleged violation is. Again, include as much information as possible, including contracts, technical documents, or any other evidence supporting the complaint. So this information is not public, which a lot of people misunderstand. So any information submitted with the complaint form is it's not public. It is discussed in executive session. It's confidential, and it stays within the board and the board staff. And a complainant cannot take over the project that they're making a complaint against. So if you're a licensee and you file a complaint against a project, you are not able to take over that project if you are the one making that complaint. So once we do get a complaint, we start our investigation process. Typically, I contact the complainant to gather more information about what's going on. Then I might contact the respondent, just again, gather more information about the complaint to assess if there is a possible violation of the act. There are times when we visit project sites if necessary. During those project sites, though, we are not doing any additional assessments. We are gathering information for the board in that case. So once our investigation is complete, we present the findings to the board, and they have various options of things to do with that complaint. So if they don't find a violation of the act, they can close the complaint. If they do, they typically initiate a case, and then that information then is discussed in executive session, and in order to figure out how to complete that complaint. So there are disciplinary actions that can follow complaints. And again, this is statute 813444. So the board can issue a censure or reprimand. They can suspend judgment, place an individual on probation, impose license limitations. That imposed license limitations typically happens when a licensee is found incompetent of a specific discipline. They can assess a civil penalty up to $10,000 per offense based on severity. They can revoke, suspend, or cancel licensure, issue a cease and desist order for projects, assess costs and fees, including attorney, hearing officer, and investigative expenses. They can also dismiss the action if there's no violations. Failure to comply and the possible penalties. So our board does report all disciplinary action to NCES and NCAR. That allows other organizations to be familiar or be aware of disciplinary action amongst licensees, and that all jurisdictions have the ability to license or to access that disciplinary information if they choose to. And a note, model law engineers, MLE, designated by NCES will lose MLE status if they have found, if they're found to have disciplinary action. So following the act can help Nebraska citizens and licensees comply with state law, protect property, protect persons on and using said property, and prevent damage or liability from improperly constructed buildings. Failure to comply with the act may result in liability for property owners and developers, including statutory fines and civil penalties, which we previously went over. Okay, so now do I need to stop? Are there any questions? No? Okay. We're going to get into some case studies. Before we dive into each case study, we're just going to go over some information to help understand the case studies a little more, just a little refresher for some. So this chart right here is Board Rule 10.3 in the handbook. This was developed by the board from state law. So this is the occupancy classification that categorizes structures based on their primary usage. Educational is typically schools, assembly is like a gymnasium, things like that. This outlines, again, the maximum building area that can be built for occupancy before licensees are required on projects. Any structure that contains 2 or more occupancies is governed by the most restrictive occupancy for the purpose of utilizing 10.3. So for example, if a building has, let's say, a business occupancy and assembly occupancy within it, to determine what the maximum building area is, you have to look at both of those occupancies and figure out which one's the most restrictive. So business occupancy less than 3,000, assembly is less than 1,000 square feet. So since assembly is more restrictive or most restrictive, that entire building area then is considered an assembly occupancy. And if that area is if that building is more than 1,000 square feet, then design professionals are required for that project. We will also talk about remediation here in some of these case studies. So just to briefly go over what remediation is, it's an informal process used by the board to involve licensed professionals on building projects in Nebraska. As you can see over there, the board has developed a guide to remediation. That is a brochure that is the publication we have that is available to anybody. And it outlines all the frequently asked questions for remediation, as well as requirements for licensees and project owners. So remediation requires those licensees to become involved in the project, whichever the board authorizes. And then those licensees review the project for any deficiencies. If deficiencies are identified, those remediation professionals must recommend design solutions to the project owners to remedy the issues. And then those project owners must correct the deficiencies identified by those professionals. So involved parties cannot have ex parte communication with individual board members. So if you're a project owner or people involved, contacting a board member directly to discuss the matter is not okay. Board members are not to have communication about projects, especially or any compliance related items outside of a board meeting. So continuing with remediation here. So again, we discussed that the remediation licensees need to submit a letter to the board. So there's an initial letter and a final letter that's required per Rule 8.4. So the initial remediation letter should reflect every step of the remediation process that's outlined in 8.4. And that needs to include the identification of the project and an explanation of the remediation professional's relationship to the project, any deficiencies, including any that raise to immediate concerns of the public safety. If there are immediate concerns, those remediation professionals should indicate whether a local authority, there is one to notify, and whether they did or did not notify them. So the licensee must include recommendations to correct the deficiencies and technical documents that may need to be produced. Remediation does not require licensees to produce new plans. It doesn't require that, but if the licensee feels that it's necessary, that is their own judgment. But again, remediation does not require new plans to be produced for the project. A letter should also include a statement affirming that that remediation professional takes responsibility for the remediation design. And then also it should include if there are other licensees that need to be involved in this project. And then those licensees complete their own letter and do their own part of the review. They then must sign, seal, and date the letter. And that letter is then presented to the project owners as well as the board. And then the final remediation letter. So once that all goes through remediation, the project owner knows what they need to do. They correct those deficiencies. A final remediation letter must be submitted that confirms the project is in compliance with the act. All of those deficiencies have been removed, and that licensee is taking responsibility for the project. Again, that letter must be sealed, signed, and dated. All right, any questions on the remediation documents there?
There isn't, but I just wanted to jump in here and make a quick point, just to underscore what remediation is for. Remediation is really a board process that helps get projects who the board discovers should have had licensees on them. In other words, they are subject to the act. That the owners, for whatever reason, didn't involve them. And so typically, instead of the board, immediately like taking the hammer down and taking disciplinary action against the owner, what the board is essentially trying to do is essentially focus on the health, safety, and welfare of the occupants and users of that building or structure. And so the remediation allows the owner to get licensees on sometimes in the middle, sometimes at the end of the project, or essentially the end, get them to review it, identify any design deficiencies, and that gives the owner an opportunity to correct those deficiencies, if any, and then ultimately get the project in compliance with the act, again, to protect health, safety, and welfare. So I just wanted to underscore that point. That's what remediation is for. It's when the board discovers a project that should have had licensees but didn't, the board will allow that owner to bring them in and then review the project and make sure it's that project is done correctly and there's no design deficiencies. So Amy, I just wanted to add that.
Yeah, nope, I appreciate that. Sometimes I forget that not everybody knows all of my thoughts in my brain. Okay, so but like John said, we are going to go through some of the case studies. So that remediation process is the informal process that we are referencing here. So this first case study, informal process for the unlicensed practice. So the board received notification of a project that was construction of a single-story, 7,500 square foot building classified as a B business occupancy. Hold on. Sorry. Okay. So as we saw back on Rule 10.3, the max building square footage for business occupancies is less than 3,000 square feet. The plans also did not bear the seal of a Nebraska licensed architect or professional engineer. So the board reviewed the project and determined that it constituted the practice of architecture and engineering and was not exempt from the act based on that square footage being greater than 3,000 square feet of that business occupancy. So the board authorized architecture and engineering remediation to bring the project into compliance with the act. The project owner then engaged a Nebraska licensed architect and professional engineer to review the project and identify deficiencies. Those remediation professionals reviewed the project, identified several deficiencies, including immediate concerns for public safety. So those licensees informed the project owner of the deficiencies and solutions to correct them. Once those deficiencies were removed, the remediation professionals completed that final letter, final review of the project and submitted a final letter to the board, again, confirming the project complies with the act, all deficiencies had been removed, and they are taking responsibility for that project. The complaint then was dismissed without disciplinary action based on the successful completion of architecture and engineering remediation. So these projects are a majority of what the board sees. Again, projects that don't involve licensees from the beginning, middle, end, whatever, but the remediation process is authorized to bring the projects into compliance. So again, this is a majority of building project complaints that the board receives and reviews. The second case study is more of the formal process, and this is about, again, the unlicensed practice. So the board received notification of the construction of a single-story 6,800 square foot building that was classified as an assembly occupancy. Again, going back to 10.3, the max building square footage for assembly occupancies is less than 1,000 square feet. In this project, the plans again did not bear the seal of a Nebraska licensed architect or professional engineer. So the board reviewed the project and determined it constituted the practice of architecture and engineering, again, not exempt from the act, as that assembly area was greater than 1,000 square feet. An assembly building, excuse me, not the area specifically. So the board authorized architecture and engineering remediation to bring the project into compliance with the act. However, in this case, the board was notified by the owner that they were not able to comply with the engineering remediation request at the time. So this project in particular went on for a significant amount of time and the engineering remediation was not getting done. Therefore, the board did hold or schedule a hearing for disciplinary action in an attempt to resolve the matter. So after that hearing, the board determined that the project that the board ordered a cease and desist for all acts constituting the unlicensed practice of engineering. They also assessed a civil penalty of $2,500 for the unlicensed practice of engineering, but that penalty was stayed for 120 days to allow the project owner to finish up that remediation within a time frame. So they had 120 days to finish up that remediation, and if they did, the $2,500 civil penalty was stayed. So the owner was able to get that engineering remediation done. The board received a final remediation letter from the professional engineer stating all deficiencies had been corrected and that the project was in compliance. At that time, the board then voted to dismiss the complaint based on the settlement agreement terms being fulfilled, and they permanently stayed that penalty, that civil penalty, based on, again, completing that engineering remediation within the 120-day time frame. Again, this projects don't typically get to the formal process, the board typically resolves matter informally. All right, number 3, case 3 is an informal process for continuing education audit failure. So during the renewal application process, a licensee attested to having satisfied the mandatory continuing education requirements for Nebraska. So this is a disclosure question when you renew your license. I'm sure you have all seen. So they stated they had satisfied those continuing education requirements. They were then notified that they were randomly selected for an audit. They submitted their CE documentations, and after review, it was determined that they had not met the CE requirements for that renewal period. The reason they didn't meet those requirements is that all hours they submitted were web-based offerings and restricted per Rule 931. So that allowed them to only count 7.5 of the 30 hours submitted. So therefore, they were 22.5 hours short of that 30-hour requirement. That licensee then was given 60 days to substantiate their claim, original claim, or earn other credit to meet those minimum requirements. In this situation, the licensee failed to respond to that failure audit notification or audit failure notification. So a settlement agreement was proposed to the licensee in an attempt to resolve the matter. Those settlement agreement terms included the licensee having to fulfill those CE audit requirements. So they needed to submit documentation showing they complied with that audit. Their license was suspended from the time of the agreement signing up to the time the licensee provided that CE audit compliance documents, or 30 days, whichever was more. So their license was suspended for a minimum of 30 days. Or until they completed the CE requirements. They also were assessed a civil penalty of $500 in investigative costs. In this situation, within a month of signing the agreement, the licensee submitted their CE documents that fulfilled the requirements, and they paid all costs. However, their license stayed placed on suspension for 30 days, and it was then changed back to active status once all the terms were fulfilled. At that time, the complaint was dismissed based on the terms of the settlement agreement being fulfilled. So again, another informal process to try to resolve the matter. Next, we're going to talk about professional conduct regarding continuing education. So if you are a licensee is selected for an audit, the licensee has 30 days from that audit notification to submit supporting CE documents. If a licensee failed to meet the audit requirements, they will have 60 days after notification to substantiate the original claim or earn other credit to meet minimum requirements. So if you fail a CE audit, you will be notified by mail and email. If you passed your audit, you're typically just notified by email. Rule 557 states that a licensee shall not deliberately make materially false statements or fail deliberately to disclose accurately and completely information requested by the board in connection with their application, license renewal application, or otherwise requested. So again, that question back in the other case study about attesting to saying that they have fulfilled those requirements and they had not, this rule then goes into effect to show why it's a violation of the act. So again, CE examples of this include reporting the mandatory CE requirements have been satisfied when they had not, and then also attesting that the information is correct to the best of your knowledge when it is not. Continuing education information. So this is the screen that I was just talking about. Your renewal, during your renewal application, you attest there to that mandatory continuing education, and then you select one of those bubbles to outline what situation fits you best. If you select that you have not satisfied the continuing education requirements in Nebraska, it will not allow you to continue with your renewal application until you have fulfilled those. As we said, fulfilling those CE requirements is a condition of license renewal. If you mark the serving on active duty or armed forces, again, that's going to stop your renewal, and myself usually will be the one to reach out asking for more documentation to substantiate that. All right, let's go over continuing education 931, Rule 931. This rule causes a lot of confusion for licensees and others, and it has been rewritten several times to try to make things more clear. So we're just going to go over it today. So web-based offerings provided by entities listed below may constitute all of the education requirement as long as they're provided by one of these entities. So IACET approved providers. If you don't know if they are or not, Google IACET approved providers. It will bring up their website. You can enter in that provider's name and it will tell you whether or not they are an approved provider there. Institutions of higher education that have an accredited program in architecture or engineering. Professional engineering or architectural societies, technical societies and associations recognized at a national level, governmental agencies, NCARB or NCES. So this one can get confusing for licensees. It needs to be provided by NCARB or NCES, not on behalf from a third party. And then AIA approved providers. So if, hold on, sorry, I'm gonna go back a second. If you complete web-based activities, so again, web-based is defined as not live or interactive, not live and interactive, then, and it's provided on the web, then it would be restricted unless it's provided by one of these entities listed in Rule 931. However, if it's live and interactive, we don't consider that web-based. So then you can get all of your hours through that time or through those entities. Web-based offerings from a provider that are not listed, like I said in that previous slide, Rule 931, may constitute no more than 1/4 of the education, which is 6 hours for architects and 7.5 for professional engineers. And then again, web-based offerings led by an instructor that enables both the instructor and attendees to give, receive, and discuss information in real time are not restricted. Even though you're doing it on the computer, just like this, if we're able to answer questions, ask questions, have dialogue back and forth, and it's in real time, it would not be considered a web-based offering.
Amy, let's pause it right here for a second.
Okay.
Because I think some licensees are getting hung up on this idea.
Okay.
So, and I just want to try to underscore. So if there is an offering that is given from one of those categories of a web-based offering that is given from one of those categories of providers, let's say NCEES or NCARB, just to make it easy for our licensees here.
Yes.
If they're giving a presentation that's not live, it doesn't matter because you can get all your hours from NCARB and or NCEES in non-live activities because they're on this list. So architects can get 24 hours from NCARB and engineers can get 30 hours from NCEES. Some other examples would be from NSPE. They're definitely a professional engineering society. AIA is one. We've actually got AIA kind of on here twice. AIA provided courses that are not live. You can get them all because they're in the third bullet. AIA approved for providers, again, you can get all your hours from them that are not live, because if they're an AIA approved provider, you can get all your hours from them, even though they're not live. So
Correct.
the issue that the board found, just for some background, is that there are some providers, and you licensees may know and come across them, that they look almost more like correspondence courses, like you maybe view a presentation or a video, and then take a quick course. There's no interaction with an instructor. You take a quick test and it's scored, and you get your results back. And the board found that a lot of those are suspect, for lack of a better word, in the board's mind. So, and the board is still going to allow some of credit from some of those providers, but you can only get a quarter of your hours max from those types of providers. So hopefully that explained. And then William has another question here about IAEI and organizations like that. And I think that he's referring to a technical society like the Steel Institute and the Wood Council and LEAD. Those are technical societies and associations. If they're recognized at a national level and they're offering provider or they're offering CE courses, the board will typically allow those if they're non-live. Catalina asked about 360 training. I don't know that provider, but if it's not live, and 360 training is not one of these 7 types of providers, then you can only get a quarter of your hours from them if you're attending a non-live, or you're participating in a non-live activity. So if it's live and it's related to the practice, you can get all your hours from those from anyone. But if it's not, they're restricted. David also asked a question about how guidance on how CE credits related to project management are handled and or treated. I will say kind of a similar question arose from the board a few years ago. And I don't know if you're going to go through this later in the presentation, but there also is a provision in the rules that says if the topic of the CE is part of your organization's body of knowledge, for example, like NSPE publishes the engineering body of knowledge, and there's a bunch of topics in there. If a licensee, if they're audited, can point to the topic of their activity as being in, for example, the NSPE body of knowledge, then usually the board will accept that, right? And James is saying Ohio has a similar rule. ASCE, David brings up, yeah, that's clearly a technical society recognized at the national level. So don't worry about ASCE at all. Yeah. So those project management, kind of firm management questions, I would always, at least on the engineering side, refer to your engineering body of knowledge. And we would also look at things like, kind of more specific types or society's body of knowledge, like IEEE and ASCE definitely. They may also have published bodies of knowledge. So engineers have a couple of them that they can rely on as far as topics go.
Yeah, rule of thumb, if it's engineering related, or you can potentially have a case or argue a case as to how it's engineering related, likely would be accepted. Same with architectural. Is it architecture related, health, safety, welfare, things like that.
Right. I will also add this because Tony asked a question about reciprocity licensing, which is really good to bring up here. Do I follow my home state or Nebraska? Nebraska has no rule about anything related to if you've satisfied the CE in your state and you passed an audit, you've satisfied Nebraska's. We don't have any rule like that. We used to, but we do not. So don't rely on any home CE rule because the board, Nebraska board, does not have one. Sorry to underscore that point, but I just don't want to get anyone caught in an audit and not realize that Nebraska does not have any reciprocity rule for continuing education.
All right, let's go on. I'm sure we'll have more questions, but again, there will be some time at the end as well. Continuing education reminders, the board has final authority with respect to approval of courses and credits. And again, the board does not pre-approve CE or courses or credits. So you can't email board staff and say, hey, does this count? We're not able to pre-approve any courses or credits. That goes with providers as well. The board doesn't pre-approve providers or courses. And as a licensee, just be on the lookout. If a CE provider says they're approved in Nebraska or all 50 states, that should be a red flag for you. Again, the board does not pre-approve any courses or providers. So therefore, there's no provider out there that's actually approved in Nebraska. So we actually are going through this with one of the PDH license organizations that provide continuing education for licensees. And I believe we just received notification that they are allowing licensees in Nebraska who did all of their hours through them or even partial hours through them to redo courses for free because they did post that their courses are approved in Nebraska, which misled licensees to think that all of the courses that they did would be approved in Nebraska, when in fact this licensee then had an audit and did not meet the requirements because those courses were restricted. So only 7.5 of those hours could be counted. So again, just be mindful when you're looking for providers, especially those like PDH whatevers. If they're saying that they're approved in Nebraska or that they're approved in all 50 states, be mindful that's not accurate, and you need to do your due diligence in figuring out for sure if that course meets Nebraska's requirements.
Amy, can you hold 1 second here?
Yep.
Because a couple people are asking about, I serve on a technical committee of ASME. How does that work with CE? I know we used to say our rules used to just talk about service as an officer on a professional or technical society. But then licensees came up to me and say, well, hey, I serve in this technical committee. We're spending lots of hours on that work. And so I just wanted licensees to be aware that there's a relatively new rule that I'm going to put in the chat that says, again, if you're serving as an officer, you can get 2 hours per year. But if you're participating in a professional or technical society's technical committee, that CE is equivalent to the actual hours that you spend on that committee. So if you're spending a lot of time, again, you're going to have to prove it to the board in a CE audit, but the board will now, if it's allowable, it'll credit the full time that you're spending on that technical committee. Again, you're going to have to prove it to the board if you're audited. So just want to add that.
Yep. We have about 10 more slides and about 3 or 4 more case studies to get through. So I'm going to try to go through them, and then we can maybe answer questions at the end if people want to stay. Okay, so case study number 4 is an example of plan stamping. So again, construction of a 6,800 square foot building classified as assembly occupancy, and it was designed by an unlicensed draftsperson. Again, over the square foot allotment of 1,000 square feet for assembly occupancies. Licensees were not directly involved throughout the prep of the technical documents in this situation. So the board reviewed the project, determined it constituted the practice of architecture and engineering, not exempt from the act based on size and occupancy. Minimum construction phase services were not being provided on the project. However, the board found no formal administrative or legal action was warranted and issued a letter of caution. So this typically happens when, let's say, a draftsperson, this is their first interaction with the board. The board, as most of you know, likes to educate, getting people up to speed on the requirements and such. So if those entities are cooperative and understanding and such, the board typically takes no formal action, but issues that letter of caution, which notes that any action going forward will likely be disciplinary action. But the project itself was designed is also in violation of the act because it does not involve those licensees. So that's a separate matter that had to be remediated on its own. This was just addressing the draftsperson unlicensed practice. So what construction phase services means, it must include regular site visits, approved technical submissions, documents submitted to the building official at permit issuance, processing technical submissions required for the contractor under those documents. Minimum construction phase services does not include the supervision of construction, review of payment applications, owner contractor disputes, and other construction administrative services. Projects subject to the act require involvement of a licensed architect or PE. Allowing construction to proceed without required professional involvement may constitute the unlawful practice of architecture or engineering, which is other case examples that we have previously talked about. So those property owners are no longer practicing architecture or engineering when that architect or professional engineer provides minimum construction phase services, or if the project is exempt from the act. Next, we're going to talk about observing versus inspecting. So observing is the ethical and legal obligation of design professionals. It confirms the general conformance with the plans, and it assists in estimating work completed. Inspecting is a higher level of evaluation and involves that close examination and qualities and conditions. And it's often associated with testing, verification, or other inspections. Direct supervision of work. We do get a lot of complaints sometimes about licensees not having direct supervision of the work. So to exercise responsible control, a supervising licensee must have authority to review, modify, reject, or approve that work in process and final deliverables through continuous oversight. So they need to be involved in the process of the project, not just designing the plans and then not being involved. They must be familiar with the project scope, requirements, limitations, and special conditions. And they should be able to explain and defend professional decisions with sufficient knowledge and proficiency. Lastly, they have to be satisfied with the completed work and accept full responsibility for the project. Some good practices to ensure that responsible control: establishing clear processes with implementing design solutions, setting expectations for on-site personnel, things like that. And then maintaining a clear chain of custody for the project information, define thresholds, follow-up, further investigation, things like that. Case study number 5. So the board received a complaint alleging a Nebraska licensed professional civil engineer was incompetent in practicing structural engineering that involved an addition to an existing building. So through the board's investigation, the board did find some evidence where the licensee could improve their knowledge or needed to improve their knowledge of structural engineering. So the board advised the licensee to complete additional coursework in structural engineering, again, to increase their competency if they intended to continue practicing structural engineering. So in this case, the licensee did do a significant amount of education, additional education, and they provided that documentation to the board. And the board in this situation dismissed the complaint without disciplinary action based on that licensee's responsiveness and additional education that they earned. Board rule, 5511 outlines competence and the requirements for licensees. And licensees must act with reasonable care and competence and shall apply technical knowledge and skill ordinarily applied by licensees of good standing in the same locality. Same goes with this rule 513 is licensees shall undertake to perform professional services only when they together have that training, education, and experience in those specific technical areas. So in Nebraska, licensed professional engineers can practice in other disciplines than which they're licensed, as long as these rules apply to them, where they have that training, education, and experience in that specific discipline. And that's for the licensee to decide. We don't have a competency test for each licensee. That is the licensee's responsibility to ensure that they are competent to do that work. A licensee shall not seal, sign, or attest to any work pertaining to any documents or that they don't have professional training and experience for. Okay, I'm gonna blaze through these next ones in hopes that we get done here soon. So case number 6, practicing without a COA, certificate of authorization. In this situation, the organization was advertising on their website that they can provide engineering services in Nebraska. The board staff received this notification. Letter was sent to the organization notifying them of the violation, and that organization responded by removing any references for engineering in Nebraska from its website. They then submitted a certificate or an application for a certificate of authorization. They also were ordered to pay in arrears fees for the time in which they should have held a certificate of authorization. So on top of the application fee, they then did have to pay those in arrears fees. The board did dismiss the complaint without disciplinary action because of the steps that the organization took. And once that COA app was approved, that organization then was able to advertise their engineering firm again on its website. We get a lot of questions about when a COA is required. So real quickly, your organization will need a certificate of authorization if it practices or offers to practice architecture or engineering in Nebraska. If it enters into an agreement to provide architectural and/or engineering related services on projects in Nebraska, or if it engages in design build, again, projects in Nebraska, or if it bills for any of those engineering or architectural services. And if they're a business entity created by law, including but not limited to a partnership, LLC, corporation, or joint venture. We do have more information on the certificate of authorization requirements and such on the board's website. The firms tab that we showed earlier has all of this information. So if you need help looking for that, visit the website there. As I know that I gave a lot of information today, the board has developed a lot of publications that assist licensees and members of the public with learning to understand or help understand statutes and rules. So these are located again on the board's website under resources, publications, and there's the Before You Build brochures. There are the Coordinating Professional, which we did not get into today, licensee seal, remediation, the handbook, things of that nature. So that again, all on our website. If you want copies, like I said in the beginning, of handbooks or any of the publications, any of the board's documents, you can click that order materials button on that page there, and Allison will send them to you free of charge. Just let her know how many you need and where to send them, and we will get them out to you. And with that, are there any other questions? Actually, before we do end up questions, just again, as a reminder, the board anticipates giving credit for this webinar, but again, the board does not pre-approve continuing education offerings, and next certificates will not be issued. You will receive an email within a week if you have attended for the whole presentation, and that email then will be your record if you're claiming it for continuing education credits. With that, John,
Yeah.
are there any additional questions?
I do have a couple.
Okay.
So John asked, is this webinar satisfied to see requirements of Rule 9.3.3? This is a live event, so this is not restricted as you know, in determining whether it's live or non-live. So just consider this a live webinar. So
I think he's actually asking about the ethics portion of it.
Oh, the ethics, right? Yeah, we did intend this to cover ethical issues of professional practice. We touched on some of the recent compliance cases we went over, some of the penalties. So yes, we did intend to cover ethics. Rich asked, is a COA required for an individual doing business as themselves? If they're not an organization, if they're, for example, if they're entering into an agreement to, you know, I'm John Doe Architect, they're entering into a contract with their client just as themselves as an individual, then they don't need a C of A. However, the COA requirements do not hinge on the number of employees. So if there's a single person who operates as John Doe LLC and enters into an agreement with a client to perform architecture as John Doe LLC, even though they're the only employee of that LLC, they do need a certificate of authorization because they are not unethically, you know, kind of using that, practicing through an LLC. There's some business and benefits to doing that, to be sure. But if they do need a certificate of authorization issued by the board. And then finally, Vincent asks, are the occupancy area limits based on habitable area or gross area? I believe it's building area, and I believe that's, we use building area, see Rule 10.2.4, and that's defined in the state building code, and I can't remember what building codes we use or the state uses right now. But we reference the state building code, so whatever the state adopts, use that definition of building area.
I believe it's 2018.
Yeah, it may be some version of the IBC, but yeah, 2018 may be what it is. Yep. And yes, individuals will have to submit a self-report to AIA on this. We will not do that. Sorry.
Well, with that, we are at 1 o'clock. So again, we appreciate everybody's attendance. If you have questions, my information is there on the screen. You can contact Allison if you need any additional marketing type information. But again, thank you for spending your lunch hour with us, and we will see you next time.